Mr. Chief Justice, and may it please the Court. Respondent does not face an imminent injury from the absence of accessibility information at the website of a hotel she has no interest in visiting. Respondent faces neither an informational injury nor a stigmatic injury. She does not face an informational injury because she has no use for the information she seeks. She's not interested in going to the hotel, so she has no reason for information about whether it is accessible. Nor does she face a stigmatic injury. This Court has held that a person is injured when she is personally subject to unequal treatment. But that requirement is not satisfied by a plaintiff who searches for hotel websites on the Internet to check whether they comply with her interpretation of the ADA. Finally, the Court should decide the question presented in this case. The circuits are divided. The question is important. The arguments are fully aired. And if the Court doesn't decide the question here, it may not have another opportunity to do so. The Court should not bless a legal strategy of filing large numbers of lawsuits, settling almost all of them, and abandoning the rare case that threatens to create adverse precedent so as to facilitate the filing of another round of lawsuits. I welcome the Court's questions.
Respondent says that she has withdrawn her suit. So why should we decide this? It seems as though it's finished.
Well, Respondent has withdrawn her suits. I mean, she hasn't promised not to bring new suits in the future, and if she doesn't, another plaintiff presumably will. Respondent's position is that any person with a disability with accessibility needs in America who visits a website can bring a lawsuit, so presumably another plaintiff will come forward and start bringing the same
Do you
claims.
admit, though, that it would be easier to simply moot this out and wait on a suit that is still pending for another round to discuss standing?
I'm actually not really sure it would be easier, because I think that even if the Court does what Respondent asked, it would still be a significant precedential decision. I mean, the Court would essentially be blessing the legal strategy over our objection of filing large numbers of lawsuits and abandoning them at the last minute, and that, I think, would create a template for future plaintiffs to rely upon. So
I'm sorry.